Good morning, I'm Rashi Goel and I'm intern at LEXIS and Company. In this video, I'll be discussing about the right of the fetus under different Indian laws. The discussion of abortion must begin and end with the definition of what one thinks of the human embryo or fetus. If one, by the application of several principles, come to the conviction that a fetus, viable or not, can be extinguished for the benefit of its mother or its own welfare. If a person argues from the premise that a human fetus may have its existence terminated for any valid reason, then the only point about which to argue is the validity of the reason asserted to be sufficient to justify the voluntary extinction of human fetus.
In general, the word person is used to denote human being, that is natural person. Through by many statutes, this term may include a firm, a labor organization, partnership association, corporation, legal representatives, and trustees. The Indian Penal Code defines the word person, which includes any company, association, or body of person, whether corporate or not. The pertinent question is that whether an unborn child is person or not.
However, there is no doubt that a fetus or a child in mother's womb is not a natural person, but there should be equally no doubt that it is a juristic or a judicial person. In all its jurisprudential jurisdictions, child is recognized as a legal person capable of inheriting or otherwise acquiring or holding the property and also other legal rights. And there should be no doubt that only a person, whether natural or juristic, is capable of acquiring those rights. The Indian law on transfer of property makes provisions regarding the transfer of property to an unborn person. The transfer cannot be made directly in favor of unborn person, but Section 5 of the Transfer of Property Act 1872 declares that the transfer is limited to living person. Such a transfer can only be made by machinery of trust. An interest may be created for the benefit of the person not in existence at the time or date of the transfer. Also, in Hindu law, a son is entitled to have reopened the partition of the ancestral property taking place while he was in the mother's womb without keeping any share reserved for him. In law of will, a child in mother's womb is considered to be in existence, and the Indian Succession Act 1925 clearly provides that all the words expressive of relationship applied to a children in a womb who is afterwards born alive.
The property cases have established this proposition that the ordinary person, when he used his children in a will, means to designate by the term children those who are conceived but not yet out of the womb. The right of the fetus that is clearly granted by the law is its right to inherit in the womb of the mother. However, the exercise of this right obviously depends upon the live birth of the fetus.
Thus, the law of the property considers the unborn child in being for all the purposes which are to its benefits, such as taking by will. After its birth, it has been held that it may maintain a statutory cause of action for the wrongful death of the parent. In addition, the child, if born alive, is permitted to maintain a cause of action for the consequences of the prenatal injuries, and if he dies from such injuries after the birth, an action will lie for his wrongful death. Thank you.